Mcculloch versus Maryland. Following the War of 1812, the United States experienced years of high inflation and general economic turmoil. In an attempt to stabilize the economy, the United States Congress chartered a second Bank of the United States in 1816. Maryland and several other states, however, opposed the competition that the new national bank created and passed such laws taxing its branches. In 1818, James Mcculloch, head of the Baltimore branch of the Second Bank of the United States, refused to pay the tax to the state of Maryland. The case worked its way through the Maryland state courts all the way to the United States Supreme Court. This is as good a stopping point as any to talk about some of the things that have come up. The issue surrounding this case is that there are local banks, state banks, already in Maryland, and they don't like the competition that this new bank, this bank sponsored by the United States Congress, has created within their state. So what has Maryland done? Maryland has taxed the Bank of the United States. This poses an interesting question. From our conversations, we know that both the federal government and the state government can tax. But can a state tax the federal government? That's a question we haven't asked yet. Well, what do we know? Who's stronger under the Constitution? If you recall, under the Articles of Confederation, state governments were stronger than the federal government. It's just the opposite under the federal system. The federal government, federal law, is stronger under the U.S. Constitution. So states should not be able to tax a federal government or a federal bank or something sponsored by Congress. Let's see how the court case turned out. The Supreme Court declared the Maryland tax unconstitutional and void. More importantly, the decision established the foundation for expanded congressional authority, meaning Congress just got a whole lot more powerful than the states. The court held that the necessary and proper clause of the Constitution allows Congress to do more than the Constitution expressly authorizes it to do. The decision allows Congress to enact nearly any law that will help it achieve any of its duties as set forth in the Constitution. For example, Congress has the express authority to regulate interstate commerce. The necessary and proper clause permits Congress to do so in ways not actually specified in the Constitution. What this court ruling means is that federal law is supreme. It supersedes, it trumps, it's more powerful than any state law, as long as the law isn't unconstitutional.